Hello, everyone. I'm Victor Manibo. I'm a senior attorney here at Wang Law Office, and you are watching the AM show, Wang Law Office's question and answer show.
Hi, my name is Ariel. I'm the host, also a senior paralegal at Wagner Office.
Here at the AM show, Ariel and I try to answer our viewers' most pressing immigration questions. We get questions from our viewers from our various platforms, and we try to compile them and give them the answers that they seek, right? And today, we got a lot of questions about a recent Supreme Court case that we think we should address because it's going to help a lot of people out there. Today, we're going to be talking about Wilkinson v. Garland, a recent U.S. Supreme Court case.
So before we start the topic, Victor, can you tell me a little bit about your background?
Sure. For those who haven't met me yet, again, my name is Victor Manibo. I'm a senior attorney here at Wang Law Office, and I've been with the firm for 12 years. I've been a lawyer for about 13 years, and I'm licensed to practice law in New York and New Jersey. However, because Wang Law Office is an immigration law firm and immigration is federal law, we are able to serve clients all over the country. I mostly do immigration litigation, meaning I help non-citizens in immigration court and prevent their removal by ICE. I also do immigration applications, meaning I help non-citizens apply for immigration status with our various agencies. Aside from being a lawyer, I'm also a science fiction writer, and I came out with a novel called The Sleepless in 2022.
Victor, I heard that there is a new Supreme Court case that is helpful for a lot of people with an order. What is that case and when did it come out?
So that case, the one that we're going to be talking about today, is called Wilkinson v. Garland. It comes from the U.S. Supreme Court case, which is the highest court in the land. It's like the very, very, very top of the entire legal system in the United States. And they just came out with a decision on March 19, 2024, that I think is going to impact a lot of people.
So how can this case be useful for some people with an order, for example?
So, as a reminder, we've talked about this in the past. The U.S. Supreme Court, when they come out with a decision, the decisions are basically laws, right? You don't really think of it as laws, but these are rules. And so Wilkinson v. Garland is a new law. It's a new rule. And every time there's a new law, there is an opportunity for someone to be able to use it if it's if it's a new immigration law, right? To use it in their immigration case and ask to reopen their removal orders based on a change in law. This is an established basis for reopening a case. Now, Wilkinson v. Garland is an immigration case that will impact a lot of people. It is a new law, and therefore it provides a basis for reopening a removal order based on a change in law if Wilkinson versus Garland applies to their case, which is what we're going to talk about today.
This is very good. Will there be a deadline to use this case for a motion to reopen? When will it be?
Yes, there is a deadline, and it's before June 17, 2024, because motions to reopen generally have a 90-day deadline. So it's 90 days from when the decision came out. You have to file your motion to reopen, basically asking the immigration court or the BIA, hey, there's this new law. Please reopen my case because this new law applies to my case. But again, you need to know, does Wilkinson v. Garland fit your situation? And I think it'll fit a lot of people's situations.
It is time for you to tell me what is this case about, right?
Right. So let's start from the beginning. What is Wilkinson v. Garland? What happened in this case? So Wilkinson is a non-citizen who entered the United States on a tourist visa over 11 years ago. And then he was arrested by ICE because he was an overstay. He was sent to immigration court, and in immigration court, he sought cancellation of removal. He said that I am eligible for this 10-year green card because I have a son who will suffer hardship without me. So that is the starting point. That's what happened in immigration court.
So before we continue on the case, can you remind us what is cancellation of removal?
Sure. So cancellation of removal is a form of relief. It's status that someone can seek in immigration court if they've been in the country for over 10 years without being sent to immigration court, and if they have good moral character, and if they have a US citizen or LPR child, spouse, or parent who will suffer exceptional and extreme hardship without them. So if you have all of those requirements, you can ask the judge to basically cancel your removal, do not remove you, and give you a green card. And that's what's commonly called 10-year green card, because you have to show that you've been here for at least 10 years.
So back to the Supreme Court case. Well, Wilkinson meet all the cancellation of removal requirement?
Yeah, he did, or at least he thought he did, right? That's why he said, "Judge, please give me a 10-year green card." But the judge disagreed. The immigration judge said, "No, I'm looking at your situation, and it looks like your son, who's 7 years old, he has some respiratory issues, is very young, financially dependent on Wilkinson." The judge said that your son will not suffer exceptional and extreme hardship even if we remove you. So the judge denied his case and said, "No, you're not going to get cancellation. You're not going to get your 10-year green card. You're going to get a removal order."
Oh, that's bad. What happened next?
And
Did
then-
Wilkinson have another chance to do anything?
Yeah, so what happened next is he appealed it to the BIA, where he lost. And then he appealed it to the Federal Circuit, where the Federal Circuit said, "Oh, no, we're not going to touch this case because, it's a cancellation case. We can't really go into the facts of that kind of case." So he lost at the Federal Circuit as well, the Third Circuit. And then he appealed to the Supreme Court, and that's where we are now.
So what is the Supreme Court decision on this?
So the Supreme Court looked at what happened and said, okay, so this is a cancellation case, and the precise issue is whether or not this kid, the 7-year-old son, will suffer exceptional and extreme hardship. That is a very specific legal term that's defined in our immigration laws, right? And the Supreme Court said, because it's a specific legal term that has to be applied to specific facts of the case, meaning Wilkinson's situation, his son's situation, because of that, it is a mixed question of law and fact. You have to combine the law and the facts. And because it's a mixed question of law and facts, the federal courts can review the decisions made by the IJ and the BIA and say, okay, you got this wrong, or you got this right. That's not what the Third Circuit did. The Third Circuit just basically said, oh, we're not going to touch that because it deals with facts. The Supreme Court said, no, this is not about facts. This is about the definition in the law of what hardship is, and that's the law combined with facts. And if you're combining law and facts, it's a mixed question that can be reviewed by the federal courts. So Supreme Court said, Wilkinson, you win. You get to go back to the Third Circuit so that they can review whether or not the BIA and the IJ made the right decision.
So what kind of situation could use this Wilkinson case? Can you give me an example?
So now we're getting into, okay, we have this decision from the Supreme Court. Who can use this, right? So very clearly, the people who have probably lost their immigration court case because they lost a cancellation of removal application can use Wilkinson, right? Wilkinson is a cancellation case. It says the cancellation denial can be reviewed by a federal court. So if you lost in the immigration court and then you lost in the BIA, the federal circuits didn't get to review your case because before this case, that review was not guaranteed, right? But now you have that opportunity. So you can use Wilkinson and say, hey, there's this new law. It applies to my case because my case is a cancellation case, especially if the cancellation of removal application was denied based on hardship, because that is the mixed question of law and fact that we're talking about, right? So that's one scenario. That's one example of people. If you have an order, you were denied cancellation because of hardship, or any of those requirements, really, because those are all legal terms. There are eligibility requirements, and they entail a mixed question of law and fact. So you can use Wilkinson to ask to reopen your case.
How about in another situation? What if my green card application is being denied by USCIS? Why now is no longer immigration court. Is that possible to use this new Supreme Court case to do something?
Yes, still, because there is a way to get review in federal court of USCIS decisions. Both USCIS decisions and immigration court BIA decisions can be reviewed by federal courts. There are specific processes to this, but that, yes, you can get there. Now, the importance of Wilkinson is that it tells federal courts specifically, circuit courts specifically, that if it's a mixed question of law and fact, you have to review it. You have jurisdiction to review it. And when it comes to green card applications, like you're asking, green card applications have a lot of mixed questions of law and fact within it to determine whether or not someone should be given a green card. One of the mixed questions of law and fact is the issue of discretion. Does this person deserve to get a green card via the exercise of discretion? Discretion has legal standards within our laws, and those standards include, okay, do they have family ties? Have they been in the United States for a long time? Do they have medical issues? And those are applied to facts. So it's a kind of mixed question of law and fact that Wilkinson says, yes, that is reviewable. Yes, that is something that federal courts can look at. So if your adjustment of status was denied based on discretion, for example, then you can use Wilkinson and say, hey, you know what? This new law says this is reviewable now and it applies to me, so please reopen my case. I just had an immigration court case where I argued this in front of a judge, and the judge agreed with me. Discretion, questions of discretion, that's a mixed question of law and fact that is covered under Wilkinson. We had a really good discussion of Wilkinson and how it applies to discretion. So not just with green cards, if you have any sort of denial with immigration court, for example, that is based on discretionary denials of relief, you can use Wilkinson to try and reopen your case.
So is there another situation that we could use this Wilkinson case?
Aside from cancellation and green cards like we talked about, there are also other reliefs that you can ask for that involve mixed questions of law and fact. For example, asylum involves mixed question of law and fact. If you're being denied asylum because of, let's say, some criminal issues, if you're being denied asylum because you committed a particularly serious crime, that term is a legal term that needs to be applied to the facts. That's a mixed question of law and fact that is reviewable, right? When we're talking about hardship waivers, we've talked about 601 in the past, 212, right? All of them entail hardship to a relative, which is very similar to hardships to the relative in the cancellation of removal field, right? So it's the same thing. It's hardship. And Wilkinson said hardship is mixed question of law and fact. It's reviewable. So if you have denial, if you have an order that is connected to or resulted from a denial of a hardship waiver, now that's going to be reviewable following Wilkinson. You can use Wilkinson as a new law as a basis for your motion to reopen. And of course, Wilkinson is a jurisdictional case about federal court jurisdiction. So like if you file a motion to reopen with immigration court or the BIA and they still say, no, Wilkinson doesn't apply, or like, we don't want to apply Wilkinson, then it paves your way to go to the federal courts to have them decided, because Wilkinson is very clear, and that's why I was saying the immigration judge I just talked about agrees. This is something that applies to a lot of situations, including discretion. So again, this is a very good case, applies to a lot of very specific situations, but very varied situations, and I think a lot of people could benefit from it.
Yes, Victor, thank you for helping our viewer to understand this Wilkinson case. And please remember, there is only some example that we just mentioned. It might be more example out there, so you should better to come here to consult to see if this Supreme Court case will help you before it's too late.
Right. So, we've been talking about mixed question of law and facts. It's also a mixed question if Wilkinson applies to the facts of your case. We're not going to know that just by talking about it on a YouTube show, right? The best way to do that is to reach out and consult with someone who knows what they're talking about. So if you think that Wilkinson might apply to your case, or to a family member's case, please feel free to reach out.
And it is the end of the show. If you have any more questions, please feel free to leave your question with any of our platform.
And as usual, I have to say at the end of the show that everything that I talked about is not legal advice. It's just my legal opinion based on my legal experience. But if you have, questions that you need legal advice for specific to you or to your family member, or if you want legal representation, please feel free to reach out to us.
Thank you, Victor, for informing us all this, and see you next time.
Okay, bye.
Bye.